What is a de novo review under ERISA? Hey folks, my name is Brandon Osterbind and I'm an injury and disability attorney here in Central Virginia, and I help people whose long-term disability claims have been denied. So the question is, what is a de novo review under the Employee Retirement Income Security Act? And bear with me because we're going to get a little technical in this video because there's a very distinct difference between a de novo review and an abuse of discretion review. So let's start from the beginning. If you have become disabled, if you've got a medical condition or you've been in an accident that has rendered you completely unable to work, and your doctors have sided with you and you've been determined to be disabled, and you filed a claim for long-term disability benefits with your employer, your claim has been denied. You appealed that claim within the 180-day window that your insurance company gave you, and they again denied your appeal, and they said that they will not provide you disability benefits. Some policies will require that you file a second appeal and others don't. So if there is no second appeal, your only option then is to file a lawsuit in federal district court. If the policy requires that you file your second appeal, make sure that you file your second appeal. If you don't, then your case will get kicked out of federal court. So make sure that you follow the internal appeal process within the insurance company. But once that is done, and once the insurance company has made a final adverse decision, then you can sue the insurance company and you can sue the benefit plan in federal district court for violating the terms of the plan and not giving you benefits when you are entitled to them. So then the question becomes, is the review that the federal district court does, is it brand new? Is it what we call de novo? Or is it under an abuse of discretion? And there are two very different standards. And I'll tell you, the courts will initially look at the insurance policy and they will presume that it's a de novo review. That means that the court is reviewing it brand new. The court can look at everything as if it has never been looked at before. And if the insurance policy grants the insurance company discretion to interpret the terms of the insurance policy, then you do not get a de novo review. You get what is called an abuse of discretion review, because the insurance contract has given the insurance company discretion in granting or denying those benefits. Then the court will review that decision for what is called an abuse of discretion, which is a much lower standard for the insurance company and a much higher standard for you to overcome. When the court is looking at the case de novo, brand new, then the court can substitute its discretion for the discretion of the claims administrator for your insurance policy. But if the review is for an abuse of discretion, then the court cannot substitute its discretion for the discretion of the claims administrator, but it can only review the claims administrator's decision for an abuse of discretion, which means that there's no substantial evidence to support the claims administrator's claim, or that the claims administrator did not go through a reasoned, principled decision-making process in coming to the conclusion that it did in denying your claim. So there are two very different standards of review that the court could use to look at your claim. Obviously, the most beneficial to you is to get a de novo review, because now the trial judge can look at all of the evidence in the case and decide, I think this guy is disabled, or I think this gal is disabled, and therefore I'm going to award benefits under this policy. But if you're reviewing under the abuse of discretion policy, the court can look at it and say, I think this guy or this gal is disabled. Unfortunately, though, the insurance company engaged in a reasoned principle review of the materials that have been submitted, and there is substantial evidence to support its opinion, denying the claim, and it did not abuse its discretion. So even though the trial judge thinks that you're disabled, he can still sustain the insurance company's denial because of a lack of abuse of discretion. So that's really the main difference between those two different standards of review. And if you have a policy and you're not sure which one would apply in this particular case, if you don't know whether discretion was given to the insurance company to make that decision, or if you don't know whether a de novo review would be appropriate or an abuse of discretion review would be appropriate, reach out to us. Send us an email or give us a call, and hopefully at this point you've obtained legal counsel to help you work through these issues and help you present your case in the light most favorable to you in federal district court. And your attorney can explain these details a little bit further. And if that's the case and we're your attorneys, we're happy to explain that in more detail. Or if we're not your attorneys and you want us to be your attorneys, give us a call. We'd be happy to sit down with you and talk about what has happened in your case to date and how we might be able to help you win your disability benefits.